Hello everyone. Welcome back to our comprehensive series on the FIDIC Yellow Book 1999. In today's video, we're embarking on an in-depth exploration of clauses 1.1.3.1 to 1.1.3.9, each vital in shaping the contractual landscape. We'll break down each clause, starting with clause 1.1.3.1, known as the base date, and continue through to clause 1.1.3.9, uncovering key insights and real-world applications. This is a content-rich episode, so grab your notes, and let's dive right in.
This date is significant in the context of the contract as it serves as a reference point for determining the responsibilities of the parties in relation to many matters under the FIDIC forms. Here are some key points related to the base date. Reference for standards. Under subclause 5.4, references in the contract to published standards are to be interpreted as references to the edition applicable on the base date, unless stated otherwise. The contractor is required to notify the contract administrator if changed or new applicable standards come into force in the country after the base date. Reference for laws. The base date serves as the reference point for the laws of the country. If any change in the laws of the country made after the base date affect the contractor's performance of his obligation under the contract, the contractor may be entitled to relief. Reference for cost indices and prices. The base date is the reference point for establishing the base cost indices and reference prices for the purpose of operating the adjustment mechanism under subclause 13.8 for changes in cost. Reference for contract price. Under the Gold Book, the contract price is based upon the contractor's price submitted to perform the design, build, and operation service priced at the base date, with other adjustments as provided for under the contract. Reference for currency exchange rates. The base date serves as the reference point for establishing the applicable currency exchange rates if no rates of exchange are stated in the relevant contract document. Reference for insurance obligations. The base date is also relevant to establishing the contractor's obligations to maintain insurance for the works against certain risks allocated to the employer. Now, let's see how this plays out in real-world projects through some fascinating case studies. Case Study 1. Infrastructure project in South Africa. This project utilized the base date to manage currency fluctuations and inflation, ensuring a fair contract price. The lesson here is the importance of clear communication and understanding of the base date's implications. Case Study 2. Highway construction in India. Ambiguities around the base date led to legal disputes in this project, emphasizing the need for clear contractual language and mutual understanding. Case Study 3. Water treatment plant in the UK. The base date was vital in handling unexpected price changes in materials, illustrating the importance of collaboration in applying contractual mechanisms. These case studies highlight the multifaceted role of the base date, from managing financial risks to preventing legal disputes. The base date in FIDIC contracts is more than just a date. It's a foundational element that shapes various contractual obligations and rights. Understanding its nuances can lead to successful project outcomes, as seen in our case studies today. If you found this video insightful until now, please like, share, and subscribe. Now check the next clause.
Moving on to clause 1.1.3.2, we explore the commencement date, a pivotal moment in any FIDIC contract. This date marks the official start of the works and has several critical implications. Start of contractual obligations. From the commencement date, the contractor begins mobilizing resources and executing the works, marking the onset of contractual responsibilities. Timeline for submissions. This date sets the timeline for various submissions by the contractor. For instance, in the RED and MDB books, a breakdown of each lump sum price must be submitted within 28 days after the commencement date. Basis for payment certificates. It serves as a reference for issuing payment certificates, with the engineer considering the contractor's breakdown in preparing payment certificates. Start of risk transfer. The commencement date also signifies the transfer of risk from the employer to the contractor, who assumes responsibility for the care of the works. Potential variations. It's vital to recognize that the actual commencement date may differ from the planned one due to various factors like delays or unforeseen conditions. Clear definition and agreement on this date are essential to prevent disputes or misunderstandings. The commencement date is more than a mere formality. It's a cornerstone that shapes the project's timeline, financial arrangements, risk management, and overall execution. Understanding its nuances is key to successful project delivery. Stay tuned as we continue to unravel the intricacies of clauses 1.1.3.3 to 1.1.3.9 in the upcoming slides. If you're finding value in this content, don't forget to like and subscribe.
Moving on to Clause 1.1.3.3, commonly known as time for completion, holds immense importance in FIDIC contracts. It refers to the designated period for completing the works or a section, as specified in Subclause 8.2, time for completion, and the contract data, with the possibility of extensions under Subclause 8.4. This time frame is calculated from the commencement date. The time for completion is more than just a deadline. It's a critical aspect of construction contracts that has far-reaching implications. Contractor's obligation. It sets the period within which the contractor must complete the works or a section of the works, including any extensions granted. Potential delay damages. If the contractor fails to meet this timeline, it may be liable for delay damages. Employer's interest. The employer relies on timely completion to avoid extra costs and to begin utilizing the constructed facility. Extension mechanism. The time for completion can be extended under specific circumstances, such as force majeure events or employer-ordered variations. The process for obtaining an extension is typically detailed in the contract. Application across different FIDIC books. Red Book. Subclause 8.4 of the Red Book provides a framework for extending the time for completion. In case of delays caused by specified factors, the contractor can seek an extension which must be agreed upon or determined by the engineer as per Subclause 3.5. Silver Book. Primarily used for turnkey projects, the Silver Book places the responsibility of delays primarily on the contractor and offers limited grounds for seeking an extension. Nonetheless, it includes provisions for extending the time for completion in specific situations. The time for completion stands as a central pillar of FIDIC contracts, influencing project timelines and shaping the contractual obligations and rights of both parties. It transcends a mere date and encompasses intricate provisions governing work execution, potential liabilities, and extension mechanisms. A comprehensive comprehension and meticulous management of this provision are indispensable for ensuring successful project delivery, be it from the perspective of the contractor or the employer. If you found this part of the video insightful, please like, share, and subscribe for more content on FIDIC contracts.
Moving on to the Clause 1.1.3.4, Tests on Completion, a pivotal aspect of FIDIC contracts. The tests on completion are vital in FIDIC contracts, serving as a critical mechanism to ascertain whether the works are complete and ready for taking over by the employer. Here's a detailed breakdown. The tests on completion are typically fully elaborated in the contract. If the contract contains only outline tests and performance guarantees, they must be developed and approved through contract processes. Under the Yellow and Silver Books, the tests on completion include pre-commissioning tests, commissioning tests, trial operation, including reliability tests, and performance tests to verify conformity with the employer's requirements and/or the schedule of guarantees. The contractor carries out these tests after providing 21 days' notice to the contract administrator, and the tests must be conducted within a further 14 days, or as otherwise agreed, on the instructed days. Unless stated otherwise in the particular conditions, any product produced during trial operation belongs to the employer. This necessitates prior arrangements by the employer for the sale, storage, or disposal of the output. Let's explore two real-world applications of this clause. Case Study 1. A hydroelectric power plant in Latin America. A complex hydroelectric power plant project required extensive testing to meet performance and safety standards. Detailed testing procedures were developed using Clause 1.1.3.4, and disputes over test results were resolved through third-party validation. Successful completion and handover, with tests on completion serving as a key milestone. Case Study 2. Airport expansion in the Middle East. An airport expansion project required comprehensive testing to comply with international aviation standards. Coordinated testing schedules were created, and ownership issues during trial operation were addressed using Clause 1.1.3.4. Successful completion, with smooth conduct of tests and validation of project readiness. In conclusion, the tests on completion are an integral part of the FIDIC contract, ensuring that the works meet the standards and requirements set forth in the contract before handover to the employer. They encompass various types of tests, each serving a specific purpose, and are governed by clear procedures and timelines. Understanding and adhering to these provisions is essential for both contractors and employers to ensure a smooth transition of ownership and compliance with contractual obligations. If you found this part of the video insightful, please like, share, and subscribe for more content on FIDIC contracts.
Moving on to Clause 1.1.3.5, known as the Taking Over Certificate. This significant document marks a turning point in the contract lifecycle, and we'll explore its implications, along with real-world case studies. Let's get started. The Taking Over Certificate is issued under Clause 10, symbolizing the moment when the employer takes over the works from the contractor. Here's what it means. Transfer of responsibility. The employer now bears the risk of loss or damage. Start of defects notification period. The contractor must fix any defects during this time. Payment. The contractor receives the balance of the contract price, minus deductions. Release of retention money. Part of the retention money may be released. Access rights. The contractor retains access to the works for obligations like defect rectification. Clearance of site. The contractor must remove all remnants within a specified timeframe. Remember, the issuance doesn't absolve the contractor of all responsibilities. Obligations persist, especially during the defects notification period. Let's look at two case studies to understand this clause in action. Case Study 1. Highway Expansion Project in Southeast Asia. A major highway expansion project in Southeast Asia was governed by the FIDIC Red Book. The project involved widening existing roads, constructing new bridges, and implementing advanced traffic management systems. The employer delayed issuing the taking over certificate, citing minor defects and incomplete works. The contractor argued that these issues did not hinder the use of the highway. Both parties referred to Clause 1.1.3.5 and agreed to a joint inspection. The employer issued the taking over certificate, and the contractor committed to rectifying the minor defects during the defects notification period. The contract stipulated that part of the retention money would be released upon the issuance of the taking over certificate. However, the employer hesitated to release the funds. The contractor invoked the terms of Clause 1.1.3.5, and the employer complied, releasing the agreed portion of the retention money. The project was successfully completed, and the taking over certificate played a crucial role in resolving disputes and ensuring a smooth transition of responsibilities. Case Study 2. Water Treatment Plant in Africa. A water treatment plant construction project in Africa was undertaken using the FIDIC Yellow Book. The project aimed to provide clean drinking water to a large urban population. Upon completion, the contractor sought payment for the completed works. The employer disputed some charges, delaying the issuance of the taking over certificate. Both parties engaged in negotiations, referring to Clause 1.1.3.5. They reached an agreement on the disputed charges, leading to the issuance of the taking over certificate and subsequent payment. After receiving the performance certificate, the contractor delayed removing surplus material and equipment from the site. The employer, referring to Clause 1.1.3.5, notified the contractor of the obligation to clear the site within 28 days. The contractor complied, avoiding potential penalties. The project was handed over successfully, with the taking over certificate serving as a key instrument in managing payment disputes and ensuring compliance with site clearance obligations. In conclusion, Clause 1.1.3.5, or the taking over certificate, is a vital aspect of FIDIC contracts. It serves as a key instrument in managing various contractual aspects, from payment to site clearance. The case studies we explored today show its practical applications and how it can be leveraged to resolve disputes and ensure smooth project execution. Stay tuned for more insights into FIDIC contracts in our upcoming videos. Thank you for watching. If you found this part of the video insightful, please like, share, and subscribe for more content on FIDIC contracts.
Moving on to Clause 1.1.3.6, known as tests after completion. This clause is vital in ensuring that the works meet the employer's requirements even after they have been taken over. Let's dive into the details. Tests after completion refer to specific tests carried out under Clause 12 after the works or a section are taken over by the employer. These tests are particularly common in process and power contracts and are often related to availability or reliability damages. They may be determined over an extended period. For instance, some process plant contracts may require a reliability test during the initial commercial operation phase. Others may require tests at specific times of the year. The key is that these tests assess whether the project functions according to the employer's requirements, even as it begins revenue generation. It's important to note that in the Red Book, tests after completion solely refer to tests, if any, specified in the contract and performed according to the particular conditions. However, the Yellow Book and Silver Book extensively discuss tests after completion. Despite this, the Yellow and Silver Books outline different procedures for conducting these tests, though both are applicable only if tests after completion are specified in the contract. In the Yellow Book, the employer conducts the tests after completion, whereas in the Silver Book, the contractor is responsible for conducting them. FIDIC itself suggests that these two alternatives have been provided to offer choices after an informed decision has been made prior to drafting the contract. FIDIC does not favor one procedure over the other for P&DB, Plant and Design Build, or EPCT, engineering, procurement, construction, and turnkey contracts. The Gold Book, on the other hand, does not incorporate tests after completion, other than the tests prior to contract completion, which are conducted years later at the end of the operation service, rather than immediately after taking over. In the Yellow Book, if tests after completion are specified in the contract, the employer conducts them in accordance with the operating and maintenance manuals provided by the contractor. During the tests, the contractor is obligated to provide any necessary guidance as required. In the Silver Book, the employer's obligation is limited to providing electricity, fuel, materials, and making the employer's personnel and plant available. The contractor, however, is responsible for providing all other required plant, equipment, and staff to carry out the tests after completion, even after the works or section have been taken over by the employer. Both the Yellow and Silver Books state in the second paragraph of subclause 12.1 that the tests after completion should be carried out as soon as reasonably practical after the takeover. The final sentence of this subclause emphasizes the need to consider the effect of the employer's prior use of the works. If the works or a section do not pass the tests after completion, subclause 12.3 comes into effect. Under this subclause, the contractor is required to rectify the works in line with subparagraph B of subclause 11.1. Furthermore, either party has the right to request a repetition of any failed tests after completion. Additionally, subclause 12.4 clarifies that in the event the works or a section fail to pass any or all of the tests after completion and the contractor pays the specified non-performance damages, as stated in the contract, are calculated using the specified method, for this failure during the defects notification period, the works or section will be considered to have successfully passed these tests after completion. This clause emphasizes the importance of thorough testing and compliance with the specified standards, ensuring that the project meets the employer's requirements and functions effectively. It provides a clear framework for both the employer and the contractor, outlining their respective responsibilities and procedures to be followed, thereby fostering transparency and accountability in the execution of the contract. If you found this part of the video insightful, please like, share, and subscribe for more content on FIDIC contracts.
Moving on to Clause 1.1.3.7, also known as the Defects Notification Period, serves as the designated time frame for reporting any defects in the works or a specific section under Subclause 11.1. This period, typically spanning 365 days, may be subject to mutual agreement between the involved parties. It commences from the completion date of the works or section, as officially certified under Subclause 10.1, and encompasses any extensions granted under Subclause 11.3. The defects notification period encompasses several key aspects that require attention. Definition and duration. The contract data specifies the exact length of the period, but it can be extended if agreed upon under Subclause 11.3. While it typically lasts for a year, it can be modified through mutual understanding. Contractor's obligations. The contractor bears the responsibility of rectifying any defects identified and completing any remaining work. The default time frame for fulfilling these duties is to be carried out before the expiry of the defects notification period or promptly thereafter, as deemed feasible. Taking over certificate. Notwithstanding any incomplete work, the contractor is entitled to a taking over certificate. However, it is imperative for the outstanding tasks to be finished within a reasonable time frame, as instructed by the contract administrator. Remedying defects. During the defects notification period, the contractor must undertake all necessary actions to address reported defects or damages. Failure to do so within a reasonable time frame provides the employer with rights as outlined in Subclause 11.4. Performance certificate. The obligation of the contractor to rectify defects ceases to exist with the issuance of the performance certificate, signifying the completion of their contractual obligations. Implications across FIDIC forms. With the exception of the Gold Book, the language relating to the contractor's obligations to rectify defects and complete outstanding work remains consistent across all FIDIC forms. This ensures a standardized and uniform approach to addressing defects and outstanding tasks in the Yellow, Red, and Silver Books. The Defects Notification Period stands as a crucial element within FIDIC contracts, guaranteeing that the works are executed to the requisite standard. It establishes clear-cut obligations for the contractor to address defects and finalize unfinished work, offering a structured process that benefits both the contractor and the employer. A comprehensive understanding of the complexities surrounding this clause is essential for both parties to effectively manage their responsibilities and rights, fostering a transparent and collaborative relationship throughout the project's life cycle. If you found this part of the video insightful, please like, share, and subscribe for more content on FIDIC contracts.
Moving on, the performance certificate referred to in Clause 1.1.3.8 holds immense significance within the realm of the FIDIC contract. Acting as a pivotal point, this certificate is bestowed upon completion of specific criteria outlined in Subclause 11.9. It symbolizes the precise moment when the employer assumes responsibility for the works. Nonetheless, it is crucial to recognize that no certificate issued under the contract can be deemed as infallible evidence of the facts attested. The presence of latent defects may come to light subsequent to the certification, revealing that the works may not entirely align with the contract. The issuance of the performance certificate is interlinked with the successful completion of designated tests and inspections. In the unfortunate event where the works or a section fail to pass any of these tests, the contractor may be subject to restrictions on their access until alterations or modifications are proposed to remedy the situation. The contractor holds the responsibility of fulfilling these adjustments within a reasonable timeframe, as specified in the notice provided by the employer. Moreover, it is worth mentioning that the definitive cessation of liability for all parties involved hinges upon the laws and jurisdiction applicable to the location where the works were executed. Many jurisdictions acknowledge the notion of latent defects and the associated issues that arise in connection with them. Numerous civil law jurisdictions additionally incorporate the concept of a generally decennial 10-year liability. To summarize, the performance certificate holds paramount importance in the realm of FIDIC contracts, denoting the transfer of responsibility to the employer and signifying the completion of mandatory tests and inspections. However, it is vital to acknowledge that it does not guarantee absolute compliance with the contract and does not necessarily indicate the termination of liability for all parties involved. If you found this part of the video insightful, please like, share, and subscribe for more content on FIDIC contracts.
In the intricate world of FIDIC contracts, clarity and precision are paramount. Clause 1.1.3.9 serves as a testament to this principle by defining two fundamental units of time: day and year. Day. A day is defined as a calendar day. This means that it includes weekends and public holidays, unlike a business day, which might exclude these. By specifying that a day refers to a calendar day, the contract ensures that there is no ambiguity in interpreting time periods stated in days. Year. A year is defined as 365 days. This straightforward definition excludes the possibility of considering a leap year, which consists of 366 days. By setting year as 365 days, the contract standardizes the measurement of time in years, ensuring consistency across various clauses and conditions. Got questions? Leave a comment below and don't forget to like, share and subscribe for more insights into the world of FIDIC contracts. Thanks for tuning in to Growth Mindset Company. Until next time, keep building that knowledge.